There's a situation where the person in fact is a tenant, but the utility is in the name of the landlord. Now, under the circumstances, there are a separate set of provisions that they have to follow that dovetail with Landlord-Tenant Act. In other words, the protections for their utility service is linked to the relationship that they have with their landlord. The most important thing is to consider what in fact is being done. Is this a situation where the landlord has failed to pay the utility and the utility service may be terminated? If that's the case, then what the tenant has the right to do is to contact the utility company directly and to see if they can work out an arrangement where they can make payment on the utility in order to continue the service. If the tenant goes to the utility company and the utility company is seeking to have the entire amount of money paid for to the utility company by the tenant needs to make sure that they stand up for their rights and inform the utility company that they're only going to be responsible for the usage that they incur on a month-to-month basis while the dispute is as yet resolved. There's actually no responsibility that the tenant would have during the course of this dispute of having to put the utility in their name. As long as they're willing to make the payments directly to the utility company should, under the law, respond to those payments and continue the service without having to change who the consumer of record is by transferring it out of the landlord's name into that of the tenant.